Hey, good morning. Yes, I'll introduce her after. You've already met her now.
Yes, I can.
Okay.
Why don't you just keep that on there and turn this one over to you?
Let me do this.
Or smart now.
Ms. Rivers, are you ready?
Yes, I'm ready.
Okay. Well, let's get on the record. Today was the day we were going to start the trial in 21 SC 179984, which is State versus Carlisle and O'Neill. Mr. Carlisle is here with his lawyer, Ms. Feely, and Mr. O'Neill is here with his lawyer, Mr. Wright, and we have Mr. Abate from the state. Ms. Feely, on behalf of Mr. Carlisle, can you let me know if Mr. Carlisle has decided, instead of going to trial, entering a plea in his case?
That's correct, Your Honor.
We're going forward with a plea.
Yes.
Okay. And Mr. Wright, same situation with Mr. O'Neill?
Yeah, sure.
Okay. And the lawyers and I spoke just before Mr. Carlisle and Mr. O'Neill, you came out here. We're going to take the plea simultaneously, meaning Mr. Abate is going to be asking many of the same questions to you together, but the answers always need to be in sequence. The court reporter needs to get an individual answer from Mr. Carlisle and from Mr. O'Neill. So just as an example, partway through this process, Mr. Abate is going to be asking, have you had enough time to speak with your lawyer? And then he'll say, Mr. Carlisle, and you'll answer, yes, no, I need more, whatever your answer is. And then he'll say, Mr. O'Neill, and you'll answer as well. But we'll do these pleas at the same time. If at any point, Mr. Carlisle or Mr. O'Neill, you want to take a break to speak privately with your lawyer, just let me know. We can pause. This is not a fast forward process. Or if someone says something that doesn't make sense or is different from what your lawyer told you was going to be going on, I need you to flag that so that we can work through your concern or your confusion. Mr. Carlisle, will you do that?
Yes, Your Honor.
And Mr. O'Neill? Great. All right. So Mr. Abate, when you are ready. Can you make the camera come up on that screen?
Mine is off.
The screen is just off?
Yes.
Oh, okay.
I'll come to over there. Okay, if you'll both raise your right hand. You both solemnly swear that the testimony you're about to give in the matter pending before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay.
Yes.
You can both put your hand down. Now, Mr. Carlisle, could you please state your true, correct, and legal name for the record?
Charles Edward Carlisle.
And Mr. O'Neill, could you also state your true, correct, and legal name for the record? And Mr. Carlisle, are you at this time taking under the influence of any alcohol, drugs, or medicine?
No.
And is there any medication that you take regularly or on a daily basis that you have not taken today?
No.
And you understand why you are here this morning to take a plea?
Yes.
And Mr. O'Neill, same question. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there any medication that you take regularly or on a daily basis that you have not taken today that would affect your ability to understand why you're here today?
No, sir.
Okay. And Mr. Carlisle, could you tell me how old are you, sir, and how far have you gone in school?
I'm 31 years old. I have graduated high school with my high school diploma.
Okay. And are you able to read, write, and understand the English language?
Yes.
And Mr. O'Neill, How old are you and how far have you gone to school?
46 years old. I graduated high school, some college.
And sir, are you able to read, write, and understand the English language?
Yes, sir.
And Mr. Carlisle, do you understand that in the indictment number 21 SC 179984, you were charged with counts 1, 2, 4, and 8, which are murder, felony murder, aggravated assault with a deadly weapon, and possession of a firearm during the commission of a felony?
Yes, sir.
And do you understand you have a right to plead either guilty or not guilty to those charges? And if you pled not guilty, remain silent, you may receive a jury trial.
Yes.
And have you reviewed the rights that you are waiving with your counsel, Ms. Feely?
Yes.
And Mr. O'Neill, do you understand that you are charged in the indictment 21 SC 179984 with counts 1, 2, 3, 4, 5, 6, 7, and then 9 and 10? Counts 1 is murder. Counts 2 and 3 are felony murders. Count 4, aggravated assault with a deadly weapon. Count 5 is also aggravated assault with a deadly weapon. Count 6, aggravated battery. Count 7 is armed robbery. And counts 9 and 10, 9 is possession of firearm during the commission of a felony. And then 10, the last count, is possession of a firearm by a convicted felon. Do you understand that those are the charges in which you are charged with in this indictment?
Yes, sir.
And sir, do you also understand that you have the right to plead either guilty or not guilty to those charges? And if you pled not guilty and remain silent, you may receive a jury trial. And have you reviewed the rights that you were waiving in order to take the reduced plea that you'll be taking today?
Yes, sir.
And Mr. Carlisle, have you had enough time to speak with your attorney, Ms. Feely?
Yes, sir.
And do you have any additional questions for your attorney at this time?
No, sir.
And are you satisfied with her services?
Yes.
And Mr. O'Neill, same questions. Do you need any additional time to speak with your attorney, Mr. Wright, about any questions that you may have at this time?
No, sir.
And are you satisfied with the services that Mr. Wright has provided?
Yes, sir.
And Ms. Feely, Mr. Wright, do you both waive formal reading of the indictment for both of the defendants?
We do.
So wait.
And Ms. Feely and Mr. Wright, do you waive any and all defects in the indictment, including any with respect to your client's name for the purposes of this plea?
We do.
So wait.
And Mr. Carlisle, has your attorney advised the minimum and maximum for the charge in which you are pleading guilty to?
Yes, sir.
Charges, excuse me. And then she advised that for the reduced count, so 1 from murder, 2 involuntary manslaughter, which is OCGA 16-5-3, that the minimum is 1 year, the maximum is 10 years.
Yes, sir.
And then as it relates to possession of a firearm during the commission of a felony, which is count 8 in the indictment, that it has to be a 5-year sentence, and it must run consecutive, but it can be probated, suspended, or served in prison.
Yes, sir.
Okay. And Mr. O'Neill, as it relates to the count that you're pleading guilty to, count 7, the armed robbery reduced to a robbery under OCGA 16-H-4, has your attorney advised that the minimum is 1 year for that and the maximum is 20 years?
Yes, sir.
And do either of you have any questions about the counts in which you're pleading guilty to and the sentences that whether it be the minimum or the maximum as it relates to each of those charges?
No, sir.
Mr. And Mr. Carlisle and Mr. O'Neill, do you understand this is a negotiated plea of guilty, which means the state and your counsel will recommend a sentence to the court, but the court does not have to accept that recommendation and can sentence you as he sees fit. And if you're pleading to multiple counts, give you the maximum for each of the counts and run them one after another consecutively.
Yes, sir.
Yes, sir.
Can you make sure you're saying Carlisle and O'Neill when
Yes.
you're asking?
Mr. Carlisle, do you understand that?
Yes, sir.
And Mr. O'Neill, do you understand that?
Yes, sir.
And Mr. Carlisle, do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal court, sir?
Yes, sir.
Mr. O'Neill, do you understand the same thing?
Yes, sir.
And Mr. Carlisle, do you understand that you waive any and all defenses by entering a plea of guilty here today?
Yes, sir.
And Mr. O'Neill, do you also understand the same?
Yes, sir.
And Mr. Carlisle, do you understand that you're pleading guilty, by pleading guilty, excuse me, you're giving up the following rights: the right to a trial by jury, the right to remain silent and to not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or court appointed if you are unable to afford an attorney at the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and to compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt by the state of Georgia, and the right to appeal if convicted of these charges after trial. Mr. O'Neill, excuse me, Mr. Carlisle, do you understand that you're waiving or giving up all of those rights by taking a plea here today?
Yes, sir.
Mr. O'Neill, do you understand the same, that you are waiving or giving up all the rights I just read by taking a guilty plea here today?
Yes, sir.
And Mr. Carlisle, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea here today?
No, sir.
And is it your decision to waive these rights and enter a guilty plea because you are in fact guilty of the two counts that you're pleading guilty to?
Yes, sir.
And Mr. O'Neill, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea here today?
No, sir.
And sir, I understand that you're pleading under North Carolina versus Alford. Are you pleading guilty because you have decided that it is in your best interest to do so? And are you aware that even if you don't admit guilt, this is a guilty plea and places you in the same position as if you were convicted by a jury for the single count that you're pleading guilty to?
Yes, sir.
And Mr. Carlisle, as it relates to count one, murder, which is being reduced to involuntary manslaughter under OCGA 16-5-3, in indictment number 21 SC 179984. How do you plead, sir?
Guilty.
And is this plea freely and voluntarily given with knowledge of that charge against you, sir?
Yes, sir.
And do you understand that you may only have a limited right to appeal this guilty plea conviction, sir?
Yes, sir.
Okay. And do you understand that you only have 4 years from today for a felony charge to file a habeas corpus petition challenging this guilty plea?
Yes, sir.
And prior to this plea, you and Ms. Feely have had the opportunity to talk about the steps in the process in filing a habeas corpus petition?
Yes, sir.
Okay. And Mr. O'Neill, how do you?
I'm sorry, before you go on to Mr. O'Neill, I thought Mr. Carlisle was pleading to count 1 and count 8.
You're right. I apologize, Your Honor.
Okay. You understand you're also entering a plea to count 8, Mr. Carlisle.
Yes,
That's the possession of a firearm during commission of a felony. That's the one where the sentence has to run consecutive to whatever you get for the involuntary manslaughter. There'll be a +5. It can be probated, suspended. It can be something that I think should be served. But as I understand it, you are today entering a plea of guilty to both those counts: involuntary manslaughter and possession of a firearm during commission of a felony. Is that correct?
yes, sir.
Okay, thank you.
Thank you, Judge. My apologies. And Mr. O'Neill, how do you plead to the charge of robbery, which is count 7, being reduced from armed robbery under OCGA 16-8-4 and indictment number 21 SC 179984?
Guilty.
And is this guilty plea?
I'm sorry to interrupt, Council. Do we need to make sure we put on the record at this point about applying the recidivist notice? Because that was something, at least as it relates to Mr. O'Neill,
I was going to ask about that later, so we'll get it covered.
just whenever the appropriate time is.
Okay.
And Mr. O'Neill, is this guilty plea freely and voluntarily given with full knowledge of the charge against you, sir?
Yes, sir.
And do you understand that you may only have a limited right to appeal this guilty plea conviction?
Yes, sir.
You also understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging this guilty plea.
Yes, sir.
And prior to today, you've had an opportunity to speak to your counsel, Mr. Wright, about all the process that entails a habeas corpus petition.
Yes, sir.
Your Honor, had this case proceeded to trial, the state would have been able to prove beyond a reasonable doubt that on November 9th, 2020, at approximately between 6:15 and 6:20 a.m. In the morning, at 2997 Campbellton Road, Southwest Atlanta, Georgia, here in Fulton County. That is Club Deja Vu, also called Club Vu. On that, I guess beginning on November 8th into November 9th, Mr. Rodriguez Jackson and Mr. Richard Giles had been out in Atlanta celebrating Mr. Giles' 27th birthday. He had come into town from Opelika, Alabama, with his fiance, and at that time, Mr. Giles and Mr. Jackson decided to go out to celebrate Mr. Giles' birthday, and they were celebrating actually Mr. Jackson's birthday, which had occurred about a month prior. The last place that they went to that early morning was Club Deja Vu. At the club, working as security guards were both the defendants, Mr. Carlisle and Mr. O'Neill. What the evidence would have shown is that Mr. Carlisle was working outside the club, kind of monitoring who comes and goes from the club. And he was one of the team members, I guess you would call it, that night on security, who were frisking individuals, making sure that they didn't enter the club with any contraband items or firearms. Mr. O'Neill was actually working inside the club. From speaking to several of the witnesses, he typically worked in the back area of the club. The club is pretty large, actually. Once you walk in, and it's almost separated into 3 separate rooms, and he was in the very back room. That was where his detail had him assigned. What the evidence would show is that Mr. Jackson and Mr. Giles arrived at the club a little after 6 a.m. And after speaking with several of the witnesses, what the evidence would show is that unbeknownst to Mr. Giles, but Mr. Jackson and Mr. O'Neill had a dispute that had been ongoing over money. And once Mr. Jackson and Mr. Giles arrived and went inside the club, that dispute continued between Mr. O'Neill and Mr. Jackson. And as a result,
When you say it continued, meaning it was a pre-existing dispute before November 9th, 2020, Mr. Jackson and Mr. O'Neill had some disagreement over or conflict around money.
that's correct.
Okay.
And once Mr. Jackson had entered the club, that dispute was very much still alive. That led to Mr. Jackson and Mr. O'Neill having words and a somewhat physical altercation, from what I understand from witnesses inside the club, which led both Mr. Jackson and Mr. Giles and Mr. O'Neill running to the front of the club. And at that point, as Mr. Jackson ran towards the club, but the door that led outside of the club, he was shot and he went down at that point. What the evidence would show is that Mr. Giles was also armed, and he did pull out a firearm as a result of Mr. Jackson being shot. At that point, as he stood on the outside of the club, I guess front steps or front porch area, he was told to put the gun down. After several requests to put the gun down, what the evidence would show is that that is when Mr. Carlisle began to fire, and he did have an AR type rifle that shot 223 bullets and struck Mr. Giles approximately 7 times. But the evidence would also show Mr. Jackson did indicate that Mr. Carlisle, for lack of better words, began to fire kind of recklessly, because what statement in which he told Detective Bender is that he fired the pistol or the rifle kind of with his eyes closed, and it was almost as if he was hesitant to fire the gun. But the trigger pull on that gun is very light, which led to the large burst that did come out of the AR style rifle. And at that point, both Mr. O'Neill and Mr. Carlisle left the scene separately, not together. And were later interviewed by the detectives, specifically Detective Bender. At that point, when first Detective Bender spoke to Mr. Carlisle, his statement to her was that he was not there. He had no idea what she was talking about. And Mr. O'Neill initially and remained steadfast with the story that he was also not present at the club at the time that all of this occurred. And cell phone records placed both Mr. O'Neill and Mr. Carlisle at the scene, as well as video surveillance from the APD Vic camera, which is on the corner of Campbellton Road and Childers Road that kind of overlooks the club, was able to catch both the vehicles that belonged to Mr. Carlisle and Mr. O'Neill leaving the club, further compounding evidence that they were both present. Obviously, both Mr. Carlisle and Mr. O'Neill have no duty to speak to the police, but I think the lack of candor in the statements that were made led to the charges and why we're here today, Your Honor. So had the state gone to trial, that's what we would have been able to prove beyond a reasonable doubt. Mr. Carlisle has no felony convictions at all. In fact, I only see that he has one arrest for, I believe it's marijuana. So he has virtually no criminal history. Mr. O'Neill does have 3 prior felony convictions. They are all very old, to be candid with the court, all out of New York, with the last one being in 2009. It was an armed robbery that was reduced to burglary, and the other 2 counts, or the other 2 convictions, were in the early 90s for theft-related charges. The state had filed a recidivist notice. At this time, we will be withdrawing that notice as it pertains to the plea that we're taking here today. The joint recommendation as it relates to Mr. Carlisle is count 1, murder be reduced to involuntary manslaughter, and the defendant receive, as it relates to that count, 10 years to serve. 3 years credit for time served, released on time served. I believe he's been in custody for 1,093 days, if my math is correct. And then as it relates to count 8, possession of a firearm during the commission of a felony, 5 years consecutive suspended. And for Mr. O'Neill, as Your Honor heard, the joint recommendation would be Mr. O'Neill plead to the reduced count of robbery from armed robbery, which he was originally indicted on in count 7, and his sentence be 15 years to serve 3 years with a credit for time served and released on time served. He served 867 days, so almost 3 years.
And then a balance probated or?
Balance probated, yes, Your Honor.
Okay. Any special conditions for either of the terms of probation?
Yes, they not return to Club Boo, or the whatever now is at 2997 Campbellton Road. It is a different establishment that is now open there, that they not work security for any businesses or in that industry as it relates, or during the time they're on probation, and to have absolutely no contact with the victim's family members and the surviving victim, Mr. Jackson.
Okay. All right. Does anyone from Mr. Giles's family want to be heard? I don't know if Mr. Jackson is here, if he wants to be heard, but I'm happy to hear from anyone affected by what happened on November 9th of 2020.
Let me check, Your Honor.
Sure. Do you think we should try to bring in Dabney? We may do a little outreach on that. Maybe it'll go away.
Mr. Giles, Mr. Jackson's mother, is gonna make a brief statement to the court.
Okay, ma'am, good morning. If you'll come, you can take a seat and just be by that microphone so the court reporter can hear you. And if you'd give me your name, please.
Good morning.
Good
My name
morning.
is Keisha Jackson Hudson.
Ms. Hudson, thank you for being here.
You're welcome, Your Honor.
And is that Hudson, Hudson?
Yes, that's
Okay.
my married name.
And you are the
I'm the
mother
mother
of
of
both
Richard
gentlemen?
Giles and Rodriguez Jackson.
Okay,
They are my number one and number two crown snatchers out of my 7 crown snatchers. They are my protector and my provider. Without them, I have no protector and no provider. That night, November the 9th, that morning, when the tragedy happened to me and my family, they had nobody out there to protect them. The guys supposed to protect that place. The owner of that place is supposed to be there to protect my boys. Nobody was there to protect them. I fear for my life. My girls fear for theirs. Somehow one of the guys got in touch with my son while he was in custody. And I just feel that, Your Honor, do what you have to do. Because we took a tremendous loss. And my life will never be the same. I have 7 kids. God have 1. And Lord knows I'm going to protect the other 6. Thank you.
thank you, Ms. Hudson. Okay. Good morning, Ms. Jackson. How are you doing?
Good morning, Your Honor. I'm great. How are you?
I'm all right. Can you share what you have criminal history-wise, first for Mr. Carlisle?
Yes, Your Honor. He has 2 cycles. The last arrest was July the 12th, 2020 in Clayton County for misdemeanor obstruction of an officer and possession and use of drug-related objects, a misdemeanor, and possession of a firearm during commission of a felony, and possession of marijuana with the intent to distribute, and possession of Schedule 1 or 2 with the intent to distribute. In the GCIC, it stated that the possession of Schedule 1 or 2 with the intent to distribute was dismissed on June the 3rd, 2021. It didn't say anything else about the other charges. He appeared to still have an old hold out of Jonesboro, Georgia for dangerous drugs. The date on that warrant was July the 13th, 2021. Nothing in addition, Your Honor.
Thank you. And how about Mr. O'Neill?
He has a total of 8 cycles. The last arrest was October the 9th, 2009 out of Statesboro, Georgia for cruelty to children in the 3rd degree and trafficking cocaine or illegal drugs, and 2 counts of possession of a firearm during commission of a felony, and 3 counts of aggravated assault and burglary and armed robbery, and 3 counts of false imprisonment. There was no disposition for that arrest. He does have prior felony convictions. One in 2009 out of New York for armed robbery, 1 in 1999 out of Bullock County, Georgia for entering an automobile. He received first offender treatment in 1998 out of Sylvania, Georgia, for theft by receiving stolen property. That case was sealed August the 21st, 1998. He does have misdemeanor convictions. 1 in 2006 out of New York for menacing in the 3rd degree. 1 in 2005 out of New York for false impersonation. And 1 in 2000 out of Screven County, Georgia for simple battery. 1 in 1995 out of Sylvania, Georgia for obstruction of an officer. Nothing in addition, Your Honor.
Thank you so much.
Sir.
All right, let's start with Mr. Carlisle and Ms. Feely. Ms. Feely, what do you want to share? Bless you.
Yes, Your Honor. So nobody is happy to be here. The court has heard the state's recommendation, and Mr. Carlisle I think had he handled things differently on the back end, might not have even ever been charged in this case because the situation happened, gunshots were heard, guns were not allowed in the club, and he retrieved the firearm and fired and only hit the person with the gun in their hands. And so from what he knew, I think this would have been a situation where if he hadn't panicked and had just talked to the police, this would certainly still have been a horrible, horrible tragedy. But I think he is not as culpable as a lot of people charged with murder in front of this court. The court heard he's 31 years old. He is a high school grad. He has a huge support system here. Well, they're not here because I told them that it was jury selection, they wouldn't be needed today. And unfortunately, things were not able to be moved around. He may have some people trickling in a little bit later. But his parents are deceased, but he is very, very loved. And when I got his case, he had already been in jail for over a year, and his support system was very unhappy about that. And so they've been very, very involved in making sure that Mr. Carlisle is taken care of. They brought his clothes for trial. He also has a 7-year-old daughter. He has been in jail for 3 years, so he has not seen her. And my youngest is also 7. So we've talked about that a lot, about how that span of time she's grown up and going into 2nd grade. He does not have much history at all. This is not something that kind of trouble he ever gets into. And I don't anticipate that we will see Mr. Carlisle again unless it's out in the community. And so we are asking the court and actually urging the court to accept the state's recommendation in this case.
All right. Mr. Carlisle, is there anything you want to add? You don't have to say anything at all, but you have a right to be heard if there is anything that you want to share.
No, Your Honor.
Okay. What is the name of your 7-year-old?
Renee Carlisle.
All right. Mr. Wright, on behalf of Mr. O'Neill.
Your Honor, we are asking that you accept the negotiated resolution. Mr. O'Neill, in this case, has always been in a different posture. Ultimately, there was an allegation that after the shooting, that my client removed something from one of the victims. And that's the basis, the factual basis for the charge. Based on that, and after considering everything that this case involved, he thought, at this point, the amount of time I've been in, the seriousness of all the other charges associated with this case, it's in my best interest to resolve it. He has 4 children. Recently, he has missed out.
They've been graduating and he hasn't been there.
2 of them graduated.
Yeah.
So not only the loss of his time in being in for a significant amount of time, but missing out on seeing some of the things that he, as a member of the family, very much would have wanted to be a part of. So he hates that any of this happened. And ultimately is asking the court to accept this recommendation. His father lives down in South Georgia, so you sort of heard in his history. So he's looking forward to being able to see his father, who's up there in age, and being able to, I guess, reestablish life outside of the custody environment that he's been in. So he is humble before the court today and simply is asking for the court to accept this negotiated resolution. He feels it is an appropriate way to resolve this case and wishes the best for all parties.
Okay. Mr. Bate, I forgot to ask you how Mr. Jackson is doing. I know he was shot and at least initially didn't seem to be able to walk or stand up, meaning at the scene. Is he mobile now?
He's still very much in the same condition. He's mobile in the sense that he uses a wheelchair in order to get around. But walking has been something he has not been able to do without a walker. And he has suffered several complications as a result of being shot that evening, that early morning. and he continues to suffer from that.
Okay, I'm sorry to hear that. Mr. Carlisle, I'll start with you. I find that there is a factual basis for your plea, and that your plea is knowing and voluntary. Knowing means you've understood what we talked about. Do you have any questions about anything anyone said?
No, Your Honor.
Okay. And voluntary means no one's forced you to enter this plea. You've decided after consulting with your lawyer, Ms. Feely, as well as your family, that this is how you want to move forward. Is that correct?
Yes, Your Honor.
All right, I'll accept your plea. I'm sentencing you pursuant to what's called the Probation Options Management Act. What that means is that while you're on probation, which you will be for a while, if you have a minor issue with probation, you and probation can figure that out. You don't have to come back to court. But if it's more serious, if you get arrested again, or if there's any substantiated contact between you and anyone associated with Ms. Hudson and her family, that's the kind of concern that would come back to me, and I'd decide what the consequences should be. Ms. Feely, do you authorize staff from my office to sign the indictment on your behalf?
Yes, Your Honor.
And Mr. Abate?
Yes, Your Honor.
Mr. Carlisle, is it all right if we electronically sign your name to the indictment indicating your plea to the reduced count 1 and count 8?
Yes, Your Honor.
All right, we'll do that. So this applies to both you and Mr. O'Neill. I won't repeat it the second time, but it was important to hear from both the lawyers the impact this has had on the two of you being away from your family. But I don't want anyone to lose sight of the forever loss for Mr. Giles's family. Mr. Giles will never see a daughter if he had one, never see his mother again, won't be able to hold family members, go to events like that, have another birthday party. And that's the most significant loss that we've got here. It sounds like Mr. Jackson continues to struggle with mobility issues because of what happened that night. And so we have a series of losses that can't be fixed. The two of you at least get to move forward. And for that, you should feel blessed. However difficult it has been for 1,093 days for you, Mr. Carlisle, and 867 days for you, Mr. O'Neill. My hope is that this brings some closure to Ms. Hudson and her family. It won't bring Mr. Giles back, and it won't magically heal Mr. Jackson. And it certainly brings closure to you, Mr. Carlisle, because as a result of this negotiated plea, you'll be released from custody very shortly. I can't remember if you're the one with potentially the Jonesboro hold or if it was Mr. O'Neill. It's you, Mr. Carlisle. Ms. Feely will look into that. If that's something that gets you stuck, they can always take you to Jonesboro, but it also may be something so old that they don't really expire, but sometimes local jurisdictions say we're not interested anymore. So if you remain in custody for more than a couple days, your family should contact Ms. Feely and she can help look into what that hold is all about. If it's active, I'm not saying it is, but we certainly heard about it from Ms. Jackson from pretrial services who has visibility into that kind of thing. I hope, Mr. Carlisle, that as you move forward, certainly you get into a different line of work where you're not needing to carry an AR style rifle for what you do, and you avoid scenarios like this because, as I said, it's created nothing but suffering for everyone who got involved. I will follow the negotiated resolution. Count 1, the state is reducing. I don't have any say in that. They're reducing count 1 to involuntary manslaughter. I'm going to change things a little bit. I'm sentencing you on count 1 to 5 years to serve 3 years with a balance probated. You'll get credit for all the days you've been in, and you've been in for just over 3 years. Count 8 has to be 5 years and has to run consecutive to count 1. I will probate that. So your total sentence is 10 years to serve 3 years with the balance probated. So you will have 7 years of probation. That's a long time. I usually don't like sentences that are that long because it's just sort of hanging over your shoulders. But this is serious enough that I want there to be a mechanism for me to address things if Ms. Feely has misunderstood who you are and what you're like. If we're back together again in 6 months because you had a gun and you brandished it, you pointed it at someone, that means I've got 6.5 years I can revoke you for, independent of whatever your new charges are. And I don't say that to sound tough or anything like that. I just need to know that if you aren't turning a corner and moving in a different direction, that I have a mechanism to keep you where maybe you ought to be if what happened on November 9th actually is not an aberration. It sounds like that's not who you are and what you normally do. But a longer probation term helps us assure that that's the case. A special condition, there'll be 3 special conditions of your probation. One is that you stay away from that address. It's not called Club Deja Vu anymore, but 2997 Campbellton Road. Don't go around there. Number 2, probably I should have listed it as number 1. It's the most important, that you have no contact with Mr. Mr. Jackson's extended family. And they may have been strangers to you. Keep it that way. Even if it's well-intended, I'm sorry about what happened to you all. Don't do that. If there's something you need to communicate to them, let Ms. Feely know, and she'll work through the DA's office to get words to that family. But otherwise, you go your way so they can go their own way. And finally, you're all done as a security guy. You can work in any other field you want, doctor, lawyer, whatever you choose to do, but no more security work. Obviously, you can't have a firearm while you're on probation anyway, and you'll be a convicted felon, so no more firearms, period. That can make security complicated, but you'll stay out of that field. Any questions about any of that?
No, Your Honor.
Mr. Abate, anything else as to Mr. Carlisle's sentence?
No, Your Honor.
Ms. Feely?
No, Your Honor.
And Ms. Feely, I appreciate you staying with this case. You and Mr. Abate are the 2 constants on this. This is one of my oldest cases, and I'm frustrated that it took this long. I'm frustrated for the family that they waited this long for whatever resolution they're getting, and I appreciate why they may be dissatisfied with the outcome, but they shouldn't have had to wait this long. And you 2 shouldn't have had to sit in jail so long with a presumption of innocence in your favor. We're past that now. You've entered a plea, but this shouldn't take so long. The pandemic didn't help. And we had a couple bumps on the road getting Mr. O'Neill counsel. Mr. Wright has seen it through to the finish. But it's high time that we get a resolution here. Turning to you, Mr. O'Neill, I find there's a factual basis for your plea. I appreciate that your plea is what we call an offered plea. So you are saying to me that you don't necessarily agree with what the state says they could prove, but you have decided after consulting with Mr. Wright and anyone else you wanted to consult with, that it's in your best interest to go forward with this plea, even though you may take to your grave the claim, I didn't take anything from Mr. Jackson. And you're free to do that, but you're also free to enter an offered plea because you've decided that's the right way forward for you. Is that a fair description of your situation?
Yes, sir.
All right, I will accept your offered plea. And I do find, I need to be able to find this, that the state could prove that you were mixed up in this in a way. And if the jury believed the witnesses who said what they said, they could disbelieve the other evidence and conclude that maybe you did take something from, well, they'd have to conclude more than maybe, that you did take something from Mr. Jackson that wasn't yours. And that would be the basis for a robbery conviction. But I also understand the hand that Mr. Abate was dealt. This case is now older, witnesses are harder to find, and maybe people now are saying things a little bit differently than what they were saying when they first spoke with the police. So here we are. I also find that your plea is knowing and voluntary. I've already told you what those things mean. And like with Mr. Carlisle, I'm sentencing you pursuant to the Probation Options Management Act. Mr. Wright, may someone from my office sign Mr. O'Neill's indictment on your behalf?
Yes, sir.
And Mr. O'Neill, can we put your signature on there as well, indicating your offered plea to count 7, which is being reduced to robbery?
Yes, Your Honor.
All right, we'll do that. And Mr. Abate, we can assign that indictment as well?
Yes, Your Honor.
It's the same indictment, it's just a different space for Mr. O'Neill. Mr. O'Neill, you've paid a price, nothing like Mr. Giles's price or Mr. Jackson's price for being mixed up in this as well. Mr. Wright argued passionately for you to get out early to be with family for important family events, and you've missed those. And I've already talked about how Mr. Giles is forever missing every event in his family. And we can't fix that. But I hope for you going forward, and your past is a little more complicated than Mr. Carlisle's, that at your age, you're done being mixed up with anything like this, which might mean you're old enough now, you don't need to be in a nightclub at 6 a.m. Maybe you're fast asleep next to your loved one and not doing whatever you were doing in room 3 at Club Deja. I will accept the negotiated resolution. I'm going to tweak it a little bit as well based on what I've heard. I don't think you ought to be on probation any longer than Mr. Carlisle. So I am sentencing you on count 7 to a sentence of 9 years to serve 2 years with the balance probated. You've done 2 years in custody. You've done 2 years plus a couple months. You were arrested later than Mr. Carlisle, so you've served a little less time, but the negotiations here were for a sentence that gets you out, not now as in this minute, but effectively now. So 9 years to serve 2 years with the balance on probation. You've got the same 3 special conditions of probation: no contact with Mr. Giles's extended family. Don't reach out to them. If you end up in a spot and Ms. Hudson's already there, or someone you know is related to Mr. Jackson or Mr. Giles, you got to turn around and be somewhere else. Stay away from 2997 Campbellton Road. And for you, no security work either. You're a big guy, do something different, but not security work while you are on probation. Obviously, no firearms for you. You were already a convicted felon, and you need to not have any going forward. I think that's it. We're going to need to get probation to give you reporting instructions, both of you. We've got Officer Evans on the call. Mr. Wright, anything else in connection with Mr. O'Neill's case?
Yeah, I think the state already announced that the recidivist notice was withdrawn. So this is not a recidivist sentence, just I guess lack of a better way of saying a normal criminal sentence.
Correct. I heard Mr. Abate say they're withdrawing their recidivist notice, and this is a non-recidivist. I think it says repeat offender on the final disposition form, but either way, it is not pursuant to 1710(7) A or C or anything else. Okay.
That was the only clarification.
Okay. Mr. O'Neill, I forgot to ask you if there was anything you wanted to say. You don't have to say anything at all, but you've got a right to be heard on anything in connection with your case. All right, Mr. Abate, anything else?
No, Your Honor.
All right. Officer Evans, let's start with Mr. Carlisle. Can you please give him his probation reporting instructions?
Yes, Your Honor. I have also emailed Attorney Feely and Attorney Wright to request their address and contact information. At this time, I will just be asking Mr. Carlisle, what county will you be residing in? Will
Jonesboro,
you release?
Clayton County.
Clayton County,
He'll
Clayton.
be in
County? Okay, and please know I also will send these reporting instructions through the jail. But you are going to report to 1331 Citizens Parkway, Suite 201, Morrow, Georgia, 30260 on July 24th, 2024 at 8:30. Failure to do so may result in a warrant for your arrest. Do you understand?
Yes.
And there's also a contact number that'll be 770-960-4100.
Okay.
Good luck to you, Mr. Carlisle.
Thank you.
And for Mr. O'Neill, no problem. So what county will you reside in?
Clayton also.
Oh, Clayton also? Okay, you also will be reporting to 1331 Citizens Parkway, Suite 201, Morrow, Georgia, 30260 on July 24th, 2024. Oh, excuse me. I'm sorry, July 25th, 2024 at 9:30 a.m. Failure to do so may result in a warrant for your arrest. Do you understand?
Yes, ma'am.
And again, I'll also provide those set instructions to the jail. And if I can have the attorneys provide that contact information via email, I appreciate it. Thank you.
Thank you, Officer Evans. I think that's it. So appreciate everyone coming together on this one, and we will release the jurors. Mr. Black, if you don't mind staying for 1 second.